Most people think private investigators are above the law, but how true is this really? Well, the truth is, we do not have any special powers. Did you hear that? PIs have zero special powers, but private investigators do have abilities that we have obtained through our training that let us do our job right. But, yes, there's always another but in there, right? Doing our jobs right doesn't mean we can cross any legal boundaries. In this video, I am going to explain exactly what private investigators can do, but more importantly, the 5 lines we should never cross. Now, when you watch movies or television shows, you see PIs breaking into homes, hacking phones and computers, tracking their subjects' every move, and even flying drones to get the video they need. Basically, the big screen depicts PIs doing whatever it takes to solve the case, get the money shot, and make the customer happy. Now, that makes for great entertainment, but it is completely disconnected from the reality of being a private investigator today.
This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today.
In the real world, a private investigator license does not grant them the authority to break the law or do whatever they darn well please. And spoiler alert here, even if your state does not have PI licensing, PIs are still not above the law, and they need to ensure they never cross those sacred lines. You need to understand that PIs do not have the right to bypass privacy rights or act like the police. We private investigators are fundamentally just private citizens who happen to work as PIs. And working in the PI field also brings a higher level of responsibilities on us because of what our profession does and because of our licensing. Now, one big difference between a PI and any other person just walking down the street is the specialized training and access to tools that help us find information legally. The key word in there is legally. You see, if a regular, normal, everyday citizen cannot legally do something, then a private investigator most likely cannot legally do it either. This is one of those foundational rules that encompass the PI profession, and understanding that rule is the key to knowing what we can and cannot do. I get clients who call on a regular basis expecting me to be able to wave some magical wand that allows me to get whatever piece of information they need, regardless of the laws involved. I have literally been asked to break into homes or offices to steal documents. I have also been asked to hack phones, laptops, and networks too. In these extreme cases, I have to explain to the client I have a high regard for the privilege of being a PI and that I will not risk losing that privilege for any case. I am always educating my clients on the fact that private investigators operate strictly within the boundaries of the law because that is the only way our evidence is valid in a courtroom. You see, many people, including PIs, do not know this. If we break the law to get evidence, that evidence can and will be quickly dismissed by a judge, but that is not the only risk we take. There is a huge risk for our client as they may very well lose their case based on the actions that we took while representing them. And attorneys don't take kindly to us taking risk with their license on the line, and that leads to the biggest risk we take when we gather evidence illegally. We essentially risk it all, folks. We risk losing the case. We risk losing the client. We risk losing our ability to even work in this amazing profession. If a court finds our work ethics questionable, they could ban any evidence that we produce in their court, essentially blocking us from ever doing work for any client whose case may go before that judge. And word gets around quickly in this industry. Attorneys talk, judges talk, court clerks talk, and PIs talk too. So how do you avoid this? Quite simple. Just do your job legally and ethically. If you get that weird feeling in your gut about what you are about to do, then you may need to take a moment and question the legality and ethical nature of what you are about to do. One of those legal boundaries we see crossed many times is when a PI is out doing surveillance and he sees activity in the subject's house through the front window. Can he watch what is happening through that window? Yes, if it is clearly visible with the naked eye from a public space, he can watch what is happening through that window. So if the PI is sitting across the street in their surveillance vehicle and they can plainly see what is going on inside, they can watch and they can document what they see. The trickiest part here, though, is when the PI decides to just grab a little bit of video footage to help prove what he saw is true. In most states, you cannot shoot video through a window without violating privacy laws, and in most cases, other laws too. And then there is the important difference between public spaces and private spaces. Like I said, if the PI is parked across the street, they can observe and document in writing what they observed. But if the PI thinks they see activity through the window, then the PI goes on foot surveillance and discovers he can only see what is happening clearly from the driveway. Well, now he is on private property, not in public space. This is also vital to remember when it comes to capturing video or photographs of your subject when they're out in the public and not at home. When a person is in a public space, they do not have a reasonable expectation of privacy. Thus, you can, in most instances, get the video you need. You have to keep in mind, though, that public spaces includes sidewalks, streets, parks, parking lots, and most shopping areas. This would then include the grocery store, a convenience store, a coffee shop, or a restaurant, and yes, even the beach. Just about anywhere the general public can go. Because of the fact that anyone can get video in these public areas legally, a private investigator can do it too. This is the core concept of why surveillance is legal in the first place. But in order to be legal, it has to be done in the confines of public spaces. We can sit in our cars parked on a public street and watch a house all day long. We can follow a subject as they drive their car to and fro along public roads all day long. We can follow them into a retail store and observe what they're buying or who they're meeting. As long as we do not cause a disturbance, harass or intimidate the subject or anyone else for that matter, we are completely within our legal rights. But the situation changes completely the moment a person enters a private space. A private space is anywhere a person has a reasonable expectation of privacy. This includes the inside of their home and their fenced backyard, and there are some private spaces in the public too, like restrooms, changing rooms, and the like. Private spaces also would include hotel rooms, private offices, and medical facilities too. Now that medical facility part is probably going to get some PIs out there in a tizzy. I know many PIs that do workers' comp or injury surveillance, and they will say that they go into doctors' offices all the time and get video of their subjects. And to me, well, this is a gray area at best. As long as they are in the waiting room, I guess it could be called a public space. But as a general rule, that doctor's office probably does not invite anyone and everyone to come in and sit there without an appointment or other business purpose that has to do with the office. This is why I refuse to go into doctor's offices for any reason except maybe on occasion just to stick my head in to see if my subject is sitting there. This is also why I have lost many clients in the past because they insisted on me going in and getting video in a doctor's office. Now, mind you, those clients I lost weren't attorneys. Those clients weren't insurance companies. Those clients were those large national PI firms. And when it comes to most of them, the person you are dealing with has probably never done an hour of surveillance, probably does not have a PI license, and is usually following some outdated guide that they go by. And the bigger problem is that the client isn't the one risking their entire career if you make the wrong choices or violate someone else's privacy. You are the one at risk, the only one that will be held responsible. The client will throw you under the bus in a heartbeat. We never told him to do that. Now back to the surveillance. If your subject walks into their house and closes the door, your ability to obtain video ends the moment they step foot inside. We cannot walk up to the house and press our faces up against the glass to see what they're doing inside. We can't step foot onto their property or climb a tree to get a view inside their backyard. There is a legal concept called curtilage, which refers to the immediate area surrounding a house. The front porch and the driveway and the back and the side yards are usually considered part of these private zones. We cannot enter those zones to conduct surveillance or plant hidden cameras. Did you hear that? We can't go onto their property to put hidden cameras there. Yes, I have had clients ask me to do this too, most of which were clients involved in a divorce or child custody matter. But yes, unfortunately, I have had attorneys ask me if this is possible. Now, you might be wondering about audio recording the subject while out in public, and I will cover that here in a minute. Surveillance is the bread and butter for most private investigators out there, and it is absolutely the best way to gather undeniable evidence of what a person is doing, to be sure. But surveillance is strictly limited to observing what is freely visible to the naked eye. Another highly controversial topic is gathering evidence using high-powered telephoto camera lenses like this one on my super zoom camera. If a person believes they're in a private setting, technically we cannot use technology to defeat their privacy. Now, I will usually use my super zoom to see far distances to see when a subject goes active or when a car is leaving a rural area, but I do not use it to try to obtain evidence of the subject themselves. Now, if I am looking for assets, looking for property like vehicles and things like that on a remote location, yes, I will take this bad boy out and grab some photos of the assets. But I never get photos or video of my subject, and yes, this does do video too. Another major area of our work involves finding hidden information about our subjects. People hire us to locate missing persons or find hidden bank accounts or run extensive background checks. To do this, we use specialized informational databases that are not available to the general public. These databases compile billions of records from public sources, credit bureaus, utility companies, and other places like that. These super secret PI databases track address history, vehicle registration, court information, and more. But having access to these powerful databases does not mean we can look up anyone for any reason. Our access is strictly governed by strict federal privacy laws and the EULA, or the End User License Agreement, with the data broker. Three of the biggest laws private investigators need to keep in mind are the FCRA, Federal Credit Reporting Act, Graham-Leach-Bliley Act, and the Driver's Privacy Protection Act. These laws dictate exactly who can access personal information and the specific reasons they are allowed to do that. We must have what is called a permissible purpose to run any search on any of these systems. A permissible purpose means there is a legally valid reason connected to an active investigation or a court case which we are working on. If we are working for an attorney who is trying to serve a subpoena, we have a permissible purpose to find that person's address. If we are investigating insurance fraud, we have permissible purpose to check for vehicle records. If we do not have a permissible purpose, we absolutely cannot run the search. It is that simple, and there are no exceptions to this rule. But yes, I know there are plenty of PIs out there running backgrounds on people without those legal purposes. And well, all I can say is that it will catch up to them eventually. I do know a couple of PIs who lost their access in the past to this type of data, and one of them lost access to multiple databases. But the risk isn't just in losing access to the data, there are legal ramifications as well. Now let's discuss this real quick. Can a private investigator lie to somebody to get them to talk? Often we need to gather information directly from people rather than from a computer screen. And much to everyone's surprise, sometimes people will not tell us the truth. They might get nervous. They might be worried that we suspect them of wrongdoing, or they might want to protect the person we're investigating. This brings us to a common investigative tactic called Pretexting. Pretexting is the act of using a scenario or a minor deception to gather basic information. In many situations, simple pretexting is completely legal and highly effective. For example, we might call a business and ask about their hours of operation to confirm our subject is working that time. We might pretend to be a delivery driver trying to confirm someone still lives at a specific address. We might pose as a customer looking for a specific employee to see if they are working at that time. This is normal investigative techniques used to verify simple facts without alerting the subject. However, there is a massive legal difference between a clever pretext and illegal fraud. We cannot pretend to be someone we are not if it causes harm or accesses legally protected information. We can't call a bank and pretend to be the account holder to get financial statements. That is called bank fraud, and it is a very serious federal crime. We cannot call a doctor's office and pretend to be a husband to get medical records for the wife. That violates strict medical privacy laws and will lead to an immediate arrest. We cannot pretend to be a utility company demanding payment to get a forwarding address. A good investigator knows exactly how to get the information they need without crossing the line into fraud. Now, here's one thing most people and PIs don't think about. If you are working for an attorney, you fall under the same laws, rules, and ethical regulations the attorney falls under. So if the attorney can't do it, well, you can't do it either as a PI. For all intents and purposes, you are an extension of the attorney, much like a paralegal or another office staff member. Let's now cut to the chase and talk about the absolute limits for private investigators, those things they must never, ever do. These are what I refer to as the 5 lines that a PI must never cross under any circumstances. Line number 1 is wiretapping and illegal audio recording. This is probably one of the most common misconceptions the public has about what we do. I have been asked many times over the years to tap someone's cell phone or bug their house. Let me be as clear as humanly possible about this topic. Wiretapping violates a federal crime, and it is completely illegal in every single state. We cannot intercept phone calls or read private text messages or hack into email accounts. We do not have the equipment to do it, and we do not have the legal authority to do it. Even passive listening can easily cross this dangerous line. If we are conducting video surveillance from a public sidewalk, we can record video all day long. But if we use a directional microphone to record a private conversation between 2 people across the street, that is illegal. Different states have different laws about recording conversations you're actually involved in yourself. Some states require only one person in the conversation to consent to being recorded, which could be you. Other states require every single person in the conversation be aware of the recording. But absolutely no state allows you to secretly record a conversation between 2 other people in a private setting. Now you may be wondering, is it ever legal for an investigator to slap a tracking device on a vehicle? And we're going to cover that in just a moment too. Line number 2 is trespassing for a better camera angle. When you're sitting on surveillance for hours, it can get incredibly frustrating to suddenly lose sight of your subject. If they walk into your backyard, you might be tempted to sneak through the bushes to get the perfect shot. You might think that walking onto the driveway for just a few seconds is no big deal. You might think that looking over a tall wooden fence is a harmless way to gather evidence. But trespassing is a crime, and it would compromise the entire integrity of your investigation. We talked about this a little before. If you obtain evidence illegally, that evidence will likely be thrown out of court. Now, line number 3 to never cross is running database queries without a permissible purpose. I mentioned the strict federal laws governing our database access earlier in this video. Those laws are strictly enforced by the database providers and the government. Every single search we run is logged and audited and stored in a permanent file. If an investigator decides to look up their ex-partner just out of random curiosity, they are breaking the law. If they run a license plate for a friend who just wants to know where someone lives, they are breaking the law. Database providers perform random audits on investigators all the time. If you access these databases without a legal purpose, you risk losing your access forever. Without database access, a private investigator today simply cannot run their business. Before we get into the final two lines you should never cross, I want to take a quick moment and ask you, if you are finding this information helpful, please take a second to like this video and subscribe to the channel. Also, consider becoming a channel member for exclusive content and behind-the-scenes insights. Just click the join button down below for more information. Now let's get back to the main topic. Line number 4 is impersonating law enforcement. This sounds completely obvious, but it happens way more often than you might think. Some investigators let their ego get the better part of them out in the field. I have known some PIs that buy shiny badges online that just so happen to look exactly like a police officer's badge. Or they wear technical clothing and act incredibly aggressive when speaking to witnesses. This could be done with the intent to imply they are working directly with the police or let someone assume they are a detective, not a PI. This is a massive mistake and a very serious crime, folks. Private investigators are not police officers, and we have no police powers. We cannot make traffic stops or arrest people or demand compliance from anyone. If a witness doesn't want to talk to us, they can simply close the door or walk away. Impersonating a police officer would not only possibly carry a heavy jail sentence, it will cost you your PI license and your business. A true professional PI is proud to be a private investigator and never needs to pretend to be anything else. We get people to talk to us by being polite, professional, and respectful. Now, line number 5 to never cross involves placing a GPS tracker on a subject's vehicle. This is another huge controversial topic, and we get calls from frantic clients all the time requesting us to do this. They suspect their partner of cheating and want us to stick a GPS tracker under the car in the middle of the night. But the laws regarding GPS tracking have evolved rapidly over the last decade to protect privacy. Placing a tracking device on a vehicle without the owner's explicit consent is illegal in most states. And in those states that allow it, well, there may be other laws that are violated in using these tracking devices. We never refer to using GPS trackers or phone trackers or app trackers as a valid method of surveillance. These digital tracking methods attempt to bypass the legal necessity of actual physical surveillance. If the client wants to know where someone is going, they have to pony up and pay for legal surveillance. And based on my experience, many PIs who do use tracking devices actually charge the client more than if they just conducted regular surveillance. They have to charge for time to place the tracker, retrieve the tracker, review the data, and act on activity. Essentially, they have to go out and do surveillance anyway because the GPS tracker really only tracks itself. It doesn't prove anyone was there or prove what they did or didn't do. To me, now this is going to step on a lot of toes, using a GPS tracking device is nothing more than a lazy shortcut that violates the subject's personal privacy and, in many instances, violates stalking laws.